So if you're an upside down homeowner or you're underwater or you're close, you want out, but you're still current on your loans and you don't want to have negative credit consequences. And let's say you've even looked into it and the bank's saying, well, for you to do a loan workout, you need to be late. Or you've talked to realtors who've done some short sales and they're saying, well, you have to be late for us to do this. Let me just tell you that with respect to a short sale done by a realtor, that's probably true. Not always. I mean, we got a few short sales done while my clients were current back in the day, but you need something more. It can't just be a standard short sale. It needs to be a short sale offer plus, because most of the servicers that I've talked with are back east. They have no idea about California anti-deficiency laws. They have no idea you're frequently, but not always, protected from the IRS and taxes in California, and they don't know how to leverage the law properly. They're not licensed to do it. However, the most important piece of leverage we have right now comes when you're current. That means their investor is probably at a minimum, if you stop paying today, 8 months away from getting the property back. But if you're working with an attorney who's going to be able to extend those timelines, it's probably closer to a year before they'll get the property back. That's significant leverage to get a deed in lieu done. Now, why is deed in lieu? You could do it as a short sale while you're current, perhaps with an attorney, but let me just give you a little bit about why the deed in lieu is really good. A short sale, the bank's going to know the contract price, and that price is frequently lower than it would be on a regular sale. So you're already likely, because the buyer's going to have to wait. It's a short sale. So that price is going to, if you're close, it's going to make you short, most likely. And then when they take out the realtor fees and the closing costs, the reason why we're talking here is because you're recognizing it's going to be difficult for you to pay off those loans. And a short sale just makes it crystal clear. So when they get it and you're negotiating over the final remark on your credit, the bank's going to say short sale settle for less than the full amount, or settled in full according to California law, but for less than the full amount. They have this crazy thing the courts have allowed them to do. So you're going to get that remark on your credit unless you probably hire a lawyer and negotiate otherwise. I mean, you can have better results, but that's the standard realtor result. Now, a deed in lieu, there is no sale of the property. There is no 6% out or 5% out for commissions. There are no 1 or 2% closing costs. So right there, you're going to be about 8% ahead, and maybe more, because as I said, frequently short sales, that if the regular property, free and clear right now, if you could sell it, was $1 million, the short sale people want to come in and get deals because the uncertainty of a short sale. So you could be like 10% lower. Like that 10% is going to obviously make you short on these deals. Now, with a deed in lieu, there's none of that. It's just, here's our property. My client's still current. Here's the California law. Here's why you should inform your investor about this deal. It's so good for them. And we sort of, in our package, we make it clear that someone, like the initial people that you're going to be contacting, it's just like a customer relations. They're not really that experienced. We have to make it clear in the file that what we're doing is different. You're represented by an attorney, and we're kind of letting them know they probably have a duty to their investor to tell them that they should consider this deal, because otherwise they could be losing. Like in the last one, when I put it all together, I was like, your investor stands to lose perhaps 15% on the value of their asset by the time they get the property back in the future, in the market that we were in just last month in Northern California, where in that particular part, prices were getting weak. And I was like, so if you wait a year, you're going to have this issue. You might even not even be able to foreclose, because California is known to put moratoriums on foreclosures when they want. So I think that we set this deed in lieu up to the point where someone below recognized it and got the file escalated within 3 weeks, which was a month or two ahead of time. I was expecting a 2 to 3 month negotiation process. I called back, checked in on the file. After about on the third week, a person picked up, said your customer relations manager didn't pick up. So I did. He explained who he was. He said he had 15 years experience. And he did, and this is true. This is why we might want to do things concurrently. He said, we prefer to do short sales. And I go, yeah. And I go, but I'm glad you told me you have 15 years experience, because I remember in the beginning of the last market, we got a lot of deeds in lieu done. And I said, sometimes my clients got deed in lieu done while they were current and for no problems with their remarks on their credit. Other times the bank came back and said, well, we'll do a deed in lieu and we'll do them on your terms, but your client has to be a month late. The servicer guidelines said they cannot do it while they're current. So we'll agree to do it after a month. And I said, and sometimes you all said no. And I said, but this time, Let me explain. California laws are now much stronger for my client, and it hurts your investor. And I really think my client's doing an excellent job here putting an offer out for your client. It's so much better that your client takes the property back now than when they get it back in a year from now. And my client's current, and she's not harming her credit at the moment. So all we have to do, all we're negotiating, my client's saying, look, she's going to forego not paying on this property for a year. That could be $60,000 at $5,000 a month. She's going to forego $60,000 in savings. And all she's saying is that, she's offering your investor, if you take the property back now, we just don't want you to have a remark on her credit. We don't want a final remark that's anything different than just saying she sold the property. And if your investor can do that, we can get this done. And the guy, it took a while. I had to talk to him about broomstick condition, proper title, like they're back east, because they're not lawyers. They know foreclosure title's okay. And I'm like, I'll make sure, working with escrow, we'll make sure, I'll work with your legal department. We'll make sure you get the exact title that you want. That will be the equivalent of foreclosure or better. Like, there are a few things. He asked the same questions a few times. I had to say, look, I will make sure my client does that. We'll put it in writing. We'll get pictures, whatever you want. And so he goes, okay. And he put me on hold for a while. He said, I'll go talk to the decision maker. He put me on hold. He came back 20 minutes later and said, we'll accept your deed in lieu. Now, I don't expect that to happen every time at all. I should tell you, sometimes it can't. We got deed in lieu accepted on my client's term. Sometimes they were modified terms that my client had to agree to. And sometimes the bank said, no, not at all. And sometimes they said, well, we'll do a short sale. So, that's the spectrum. Different banks, different investors can have different responses. And yes, if we're doing a deed in lieu, I do charge legal fees for that. And I can tell you that the fees will range from $2,000 to $5,000, depending on how much work I'm going to do and whether you want to help out or, it's really how much work I'm going to do. However, and I'm willing to negotiate too, right? I mean, I'm not saying it has to be this. It's negotiable. We'll talk. We'll see whether we think we're a good fit. We work together well. I'm going to be listening for things that I need to know that I think you're going to be the type of client that works well with me. But that's what our consult will be about. But just know that's where it would be. But the other thing is, now let's say you're only interested in doing a deed in lieu and you're only interested in doing while you're current. Well, we're just evaluating then how much you're willing to risk in fees with an unknown outcome that I will work hard for, but it'll be unknown. And I'll explain all the reasons why I think it might work or might not work during our consult. However, if you're saying, I know I want out and I'd like to time my short sale, and John, when you brought up the fact that I might not have to pay for it, let's just call it 8 months or longer because of the law, that's interesting to me. And if we could time so that I'm going to spend that much time on the property not paying and then we do a short sale in the end, I'd consider that. Well, that's another possibility. So we start with the deed in lieu while you're current. We protect your credit. If the bank doesn't agree to it, then you go into the short sale. Now, we've already done a deed in lieu package, a base deed in lieu package without the lawyering would be just like a short sale package. So we're already prepared. I've already started negotiations with the bank. So anywhere in California, we either bring a realtor in on our network, a network that I've started at underwaterrealestate.com, or we work with a realtor in your area that has experience. Like, it could be your friend, but I need some experience there. We need to have, more than just a sentient being. We need someone who understands what we're doing and can represent you well to the buyers in our process. But we'll work with them. I'm also a broker and an attorney, so I can be sort of a co-broker with them and share the fees. And if the short sale succeeds, the banks pay the realtor fees always in every short sale I've ever done. And when I get paid at closing, I will return your legal fee. So you've got 2 shots at this now. If you'd like to learn more, just go to, in this case, we're going to go at listingattorney.com and or fill out this form and we'll contact you to set up a time for a consult. Thanks. My name's John McConnin. I'm a real estate attorney and a broker in California. I founded UpsideDownRealEstate.com in 2007. And I was asked by the California Association of Realtors to train realtors on how to list, negotiate and sell short sales. I was asked by Carr to teach them because I was having success back when the market was very difficult for realtors. And it might be again for reasons we don't have to talk to you about right here, but you definitely want to put an attorney on your team, at least to negotiate the approval language and the approval letters on a short sale. Thanks. Talk to you later. Bye.